Good afternoon, respected judges and dear participants. Welcome to the 12th RCL National Moot Court Competition 2024. Before we begin with the semi-final round, I'd like to share some rules and regulations. There shall be a semi-final round and only 2 teams shall qualify to the finals according to the score of the semi-final round. Each team shall have 2 pre-appointed speakers for each round who shall remain the same in all the rounds. Each team will get a total of 25 minutes, including the time for rebuttal and surrebuttal. Any extension of time shall be subject to the discretion of the judges. The division of time between the speakers is the discretion of team members, subject to a minimum of 10 minutes for one speaker, including rebuttal. The speakers are required to tell the division of time before the commencement of the round to the respected judges and readers. With this, I request the teams to kindly tell their division of time.
For the notice of the respected bench and the organizers, we'll be using 23 minutes for our submissions, and 2 minutes we'll be saving for our rebuttals. And in that, the division would be 11.5 and 11.5 for each speaker. Thank you.
Ma'am, thank you so much.
Hi, am I audible and visible?
Yes, sir.
Hi. For the side respondents, we'll be reserving 3 minutes for rebuttals and 11 minutes per speaker.
Okay, sir.
Thank you so much.
Thank you so much, everyone. With due permission of our judges, let's start our semi-finals. I wish you all the very best.
Yes, you may start.
The counsel seeks permission to approach the bench.
You have the permission to approach the bench.
Much obliged. The counsel seeks permission to address the bench collectively as your lordships.
You have the permission.
Much obliged. The counsel seeks permission to address the bench regarding the facts of the case.
Please.
The petitioner, Alex, Jordan Singh and Taylor Singh are in an interfaith relationship and wish to marry, with Alex voluntarily seeking to convert to Taylor's religion. However, the district magistrate denied permission for the conversion after an inquiry prompted by concerns from Alex's family. Despite Alex reaffirming that his decision was voluntary, aggrieved by this infringement on their fundamental rights, the petitioners had approached the High Court of Andhra Pradesh. High Court dispersed the petition and upheld the validity of Unlawful Conversion of Religion Act 2023 and also booked Alex and Taylor under Section 3 and 10 of the Act. Now, the aggrieved petitioners have approached this Honorable Court of Bharat, the Supreme Court of Bharat, for the same. If the court is satisfied with the perusal of the fact, the counsel seeks permission. Thank you. Much obliged, Your Honor. So, if the petitioners invoke the jurisdiction of Honorable Supreme Court of Bharat under Article 32 of Constitution of Bharat, challenging the constitutionality of Prohibition of Unlawful Religion Act 2023. The Act violates the petitioners' fundamental rights guaranteed under Article 14, 19 Clause 1A, 21 and 25 of the Constitution by imposing unreasonable restrictions on freedom of religion, expression and personal liberty. With your Lordship's permission, I will address issue 1 and 4 together, as both involve unconstitutional restrictions imposed by the Act on voluntary religious conversions and petitioners' right to marry, and my co-counsel will be addressing issue 2 and 3.
Okay.
Much obliged, Your Honor. The first issue, as it is read, talks about the Unlawful Conversion of Religion Act 2023 and how it restricts, how it is infringing the fundamental right of Article 25 and particularly in the context of voluntary religious conversion. If it may please your lords, I, appearing on behalf of the petitioner, will address the unconstitutionality of the Prohibition of Unlawful Conversion of Religion Act 2024 in 3 folds. The first, much obliged, Your Honor. The first fold, the infringement on fundamental rights to freedom of religion under Article 25. The arbitrary restrictions imposed by the Act on the citizens. And and does it serve the legitimate state interest? Thirdly, the violation of constitutional morality and personal autonomy by allowing excessive state interference in private religious matters. Article 25, Clause 1 guarantees right to religion, that is right to religious freedom, and it lets the citizens to profess, practice, and propagate their right as well. But it is subject to public morality, order, and health. The right to voluntarily convert to another religion is an inherent part of freedom of conscience, and it is protected under Article 25. It is humbly submitted that the Apex Court in SP Mittal versus Union of India had held that state cannot interfere with religious practices unless they harm public order, morality, or health. The conversions in question hasn't gone against any of these three aspects, and it is very clear as the sky from the facts of the case. It is also humbly submitted that the act in issue imposes unreasonable restrictions by requiring a preemptive inquiry into personal religious decision, which violates Article 25.
But counsel, the bench has one question.
Yes.
Conversion of religion only for the purpose of marriage will be covered under morality or not?
Indeed, Your Honor, that is a great question. My co-counsel will be furthering upon this question. So, because it is part of issue 2 and 3. So, if I beg your pardon, can I continue with my submissions, Your Honor?
Yes, you may continue.
Thank you. Much obliged. It is humbly submitted that voluntary conversion is a facet of freedom of religion under the freedom of conscience guaranteed by the Constitution. Article 25 protects the right to voluntarily convert as part of an individual's freedom to profess and practice religion. Aruna Roy versus Union of India, the Apex Court had held that while state can release religious content for the sake of public welfare, it cannot unduly involve in personal matters. The Prohibition of Unlawful Conversion Act does the exact same thing. It can regulate, but it is unduly involving into the personal matters of an individual, such as marriage and conversion, which is related to their freedom. Additionally, the International Covenant on Civil and Political Rights, to which India is a signatory, protects the right to change religion under Article 18. The Act is violative of international law, furthering infringement of fundamental rights. I would like to mention that, my lord, it only has a persuasive effect, but I humbly submit that it would be great if the bench takes this into consideration. It is also humbly submitted that the Act perceives fraudulent intent behind every conversion, even conversions which are done in bona fide faith and good intention. On that also, unduly it is, expressed that it is a fraudulent conversion. In Shaira Banu versus Union of India and in Justice K.S. Puttasamy versus Union of India, the court emphasized personal choices concerning faith and religion should not be subject to arbitrary state interference. The Act's inquiry process constitutes such arbitrary interference. In Justice K.S. Puttasamy, the court held that any state action infringing fundamental right must pass the test of compelling state interest. The Act in question fails to demonstrate any such compelling state interest, particularly for our voluntary conversion like that of petitioners. The statute is humbly submitted that there is an absence of legitimate state interest. The statute failed to demonstrate any legitimate state interest in this aspect. Involving into personal lives of citizens is definitely not part of state interest. Henceforth, the council would like to emphasize to the case of Inder Das versus State of Assam that Honorable Court emphasized that restrictions on fundamental rights must be backed by compelling state interest and must be necessary for a democratic society.
But counsel, don't you think that maintaining law and order comes under the purview of the state interest? And due to these irregular conversions, there may be some communal disharmony within the society?
Indeed, Your Honor, that is a genuine concern that the state can have. But the inquiry process that is put upon them, there is no proper aspect as to how to differentiate between voluntary conversions and involuntary conversions. There is no, specific aspect as to this is what voluntary conversions are, this is what involuntary conversions are. All of them are considered to be criminals, or all of them are considered since.
So you are saying that if they provide some definition or regulate the procedure, then the virus of the act goes away?
Within my limited knowledge, Your Honor, I would say that if there is a clear bifurcation as to how this procedure should go on from the act at hand, section 3, 8, 9, and 10, all of the provisions that is given in the memorial, it is said that there is no clear bifurcation between voluntary conversions and involuntary conversions. Now, if there is a bifurcation, or if there is a way that this can be bifurcated, then from my limited knowledge, Your Honor, I feel like the council feels like there can be a reason. But as of now, for the case at hand, all of them are considered to be criminals. All of them are unlawfully while they have the right to marriage, which will be substantiated by my co-counsel, right to marriage that has been infringed, and they're wrongly convicted. While interfaith marriages are a very delicate issue to be touched upon, in this circumstance, it's making it more difficult. The lives of these people are being made more difficult while living in a secular country like India. It affects the secular fabric of the country. If the bench is satisfied, can I move on to my further submissions?
Please move on.
Thank you. It is humbly submitted that Act fails the proportionalities test as it imposes blanket restrictions on all conversions, regardless of circumstances, and subjects personal religious decisions to state approval, which is blatantly not what is in state's legitimate interest. In Anuradha Basin versus Union of India, the Supreme Court ruled that any restrictions on fundamental right must be least restrictive means available and proportionate to the object. The Act exceeds these limits by imposing excessive and disproportionate restrictions on voluntary conversions. The Act violates the right to personal autonomy as iterated in Shafin Jahan versus Ashokan KM, but the court upheld the right to convert and marry as a matter of personal liberty. Right to marry is a matter of personal liberty, and personal liberty, Article 21, Article 14, and consequently Article 19, as per the rule of a golden triangle, is being restricted here. On top of that, I would like to bring the focus of the court to the term allurement. The term allurement is very vaguely put, because in Kartar Singh versus State of Punjab, the court emphasized that vague laws can trap innocent individuals without fair warning. The broad definition of allurement subjects even legitimate conversions to suspicion and fear of legal repercussion without providing adequate consequences, adequate guidance on what constitutes an unlawful incentive. In conclusion, Your Lordship, the Petitioner Council had addressed the unconstitutionality of prohibition of unlawful conversion of Religion Act 2024 in three folds. That is Article 25, imposition of arbitrary restrictions and personal autonomy. If the bench is satisfied with the submissions for issue 1, the council requests to move on to the issue 4.
Please move on to the issue 4.
Much obliged, Your Honor. So, as to the fourth issue, states' restrictions on right to marry is something that the council will be dealing with. States' regulation through the Act serve a legitimate public interest is the second thing. And third thing, it is restrictions by the state on conversions must be narrow is something that the council would try to establish through her arguments. So, Article 25 of the Constitution, as established in issue 1, provides right to religious freedom, and also reasonable restrictions are put on. All of these has established in the first issue, and the Supreme Court in Kushbu versus Kanyamal, in Puttaswamy versus Union of India, and Biju Emmanuel versus State of Kerala has said that restrictions on fundamental rights, especially those involving personal religious freedom, must be narrow and not exceed what is necessary to achieve state object, while clearly this act is exceeding of their constitutional powers or their legitimate interest. And also the act disproportionately. The second issue is that states' restrictions on right to marry are not justified, because as stated earlier, Shafin Jahan, the court recognized the right of adults to marry a person of their choice, particularly in case of interfaith marriages. Thirdly, the council would like to move on to the states' regulation through the act does not serve legitimate public interest as well. The council.
But how would you like to answer that when you say that state cannot regulate the person's choice to marry the person whom he or she likes, when there is already a statute by way of Special Marriage Act? Yes, and people of different religions can come and get married under that act.
Yes.
So how do you justify your argument that state cannot regulate further?
Sir, my argument, Your Honor, Your Lordship, my argument is that state should involve, but the involvement in such a way that is put up in the case Reasonable restrictions are there under Article 25, yes. But the way in which it is done, that is through inquiry process which are burdensome, which is, wrongly coloring them in one particular way and saying them that all conversions are allurement or undue influence. The way, the method that this is being put up is is not right, is what the council would humbly like to submit from her limited knowledge, Your Honor.
Okay.
So that is the submissions for the fourth issue. In a state regulation must serve a legitimate public interest and be proportionate to its objective. In Anuj Garg's Hotel Administration of India, the Supreme Court held that restrictions on fundamental rights must be least restrictive means available to achieve state's objective. With that, the council would like to conclude her arguments for issue 1 and issue 4. It was a pleasure to be in front of this bench today. My co-counsel will be handling issue 2 and issue 3.
Good.
Thank you.
If your lordship may permit, the council would like to address the issue 2
You
and
have the
3.
permission. Please continue.
Much
Start with
obliged, your
issue 2.
lordship. Much obliged, your lordship. Through issue 2, we're here to establish that the sections 8 and 9 of the Prohibition of Unlawful Conversion of Religion Act are outrightly violative of right to privacy and personal liberty under Article 21. Sections 8 and 9 primarily touch upon Section 9 touches upon the inquiry process, mandatory inquiry process, and Section 8 touches upon the declaration which is sought to be given 60 days prior to the planned conversion date. Going forward with this, your lordship, the right to choose a life partner is nowhere. The right to choose a life partner is a right that is vested upon all persons, and it is meant to be nowhere affected by matters of faith. The choice herein pertaining to not just the choice of life partner, but also the choice of faith to practice is also an aspect that every person is provided with as a right to try to practice as such. And this is an observation that has been made by the Honorable Supreme Court in Shafin Jahan versus Ashokan KM. Moving forward, the Law Commission of India, through its 235th report, has itself observed that that any procedure or any registration and declaration will make the bona fide converts handicapped. Even in the instant case, the procedure of 60 days prior declaration and an investigation to be done within 21 days, especially that the inquiry process being very vaguely elaborated upon through the impugn statute, which does not neither talk about by when, what are the timelines, and by when does the district magistrate provide a decision in regarding to this, is all primarily violative of the interests and rights of all persons like that of petitioners. This is not just an issue of the petitioners, your lordship. Moving forward, the right, as I already mentioned, the right to practice a religion, as mentioned by my co-counsel, is also a right that is impliedly being violated as the international covenants, be it ICCPR or the Universal Declaration of Human Rights. It emphasizes on the right to freedom of conscience, and within it, it vests the right to renounce one's religion and embrace another voluntarily. And this right is outrightly being violated because the individual autonomy of an individual in taking decisions is being subject to the order of the district magistrate. Moreover, the Article 13, Clause 2 prohibits any laws made by the legislature which infringes the fundamental rights guaranteed under the Constitution, which is also being infringed upon here. Moreover, the Supreme Court had emphasized that no class legislation, it had provided that there is a possibility that reasonable legislations can be made, but no class legislations can be made, is a observation that the Honorable Apex Court made in R.K. Garg versus Union of India. And I am emphasizing on this case is because the right to practice a religion in the manner that they want to, for a person who chooses to convert alone, is being subjected to legal and administrative scrutiny outrightly, your lordship. Moving forward, Article 21 to be conjunctively read with
So
Article 4.
can you answer the morality part? How it is morally correct to change one's own religion?
Your lordship, every individual has a right to believe in what they believe, and I would like to address, if the lordship shall permit, I'd like to address this question of morality in light of explaining the right to think that is also vested. If your lordship may permit.
Yes, you have the permission.
The Apex Court observed that a person's mental integrity and privacy sanctions with freedom to believe in what is right to think the freedom of self-determination is something that was observed by the Honorable Apex Court in case Puttasamy versus Union of India, a decision authored by Justice Dhananjay D.Y. Chandrachud. Now, why am I taking a reference to this judgment is because every individual has a right to bona fide, right to convert, right to choose to believe in a religion of in which they were not born into. The accidents of birth can't determine the religion that they shall practice for life. And the concept of morality would also support that person's intentions if they are bona fide in nature. And imposing a law which is being the same to all persons who are in a bona fide manner converting, and a person who's not willfully converting will not be right as any given the proceed. If I may continue.
Yes, yes,
uh,
you may continue.
yeah, so the procedure is being similarly adjudicated upon both the parties. But the aspect of marriage, most commonly the argument raised upon by the respondents is that marriage and conversion can't occur for each of those purposes. Like a person can't marry for conversion, and a person can't convert for marriage. So when I say that it is in the facts of this case also, there is a possibility that a contention could arise that the para 2 line 1 says that he chose there was a personal choice to convert, but at the same time it was also to unite. But merely for the fact that a person chose to marry, that can't be the reason why a person's willful decision to practice a particular religion can be subjected to judicial or administrative scrutiny.
So
That
this
is
is what the act is trying to do. It is trying to stop the conversion only for the purpose of marriage.
it,
Don't you
even if,
think?
sir, indeed, Your Lordship. Answering on this, Your Lordship, if Your Lordship may permit.
Yes, yes. Continue.
Merely because a person is converting at a timeline close to that of their marriage, that doesn't mean that they would not want to believe in another religion. I would like to emphasize on this regard because if a person is choosing willfully to convert to another religion, they are outrightly aware of the practices and they're ready to undergo a ceremony that in itself emphasizes the fact that they believe in that religion. Thus, it is imperative that we are mindful of the fact that a person's belief is not put to test. A person is not supposed to undergo a judicial answering as to the fact that they believe this. They should not be made to provide circumstantial evidence for the fact that they believe. That is something that the impugned statute is outrightly, it is questioning a person's right to think. It is asking a person, why do you think so? That
So you are saying that belief cannot be tested. There is no way for to test the belief of a person, whether it has changed and how much it has changed.
the
This
belief
is
of
what
a
you are trying to
person,
say?
the council begs to differ on what the
Okay.
lordship said. Uh, Council herein tries to establish that belief can be tested. The ceremony that the person undergoes, that itself implies that there was a belief in that religion, which is why the person undergoes a ceremony. And even if a person does not there's no statutory mandate to undergo a ceremony for conversion too. Moreover, thus,
But
I
that wouldn't be presumptuous. Uh, it will be wrong to presume that if a person undergoes a particular ceremony for change of his religion, you are attaching a presumption to it that he is going through it bona fidely.
Your lordship, I understand your lordship, but the council would like to say herein that, as you said, as lordship said, that there may be a presumption imposed if we presume that merely because the person is subjecting themselves to a ceremony that can't be considered for bona fide reasons. At the same time, the presumption that merely because they are taking a ceremony, that doesn't mean they are not doing it in a bona fide manner will also operate as a presumption.
So how would you
And
test that?
your lordship, the conversions are willful. The genuineness of the conversions can be tested in its own manner in regard to the reason, the cause behind which the conversion has occurred, which is faith. And
Hmm.
the faith can be analyzed upon the ceremony as such outrightly is being taken by a person, and they are subjecting themselves to the religious practices of another religion that they were formerly not belonging to. That in itself impliedly shows that they are accepting of religious practices, because quite often persons practicing a religion may not be believing in the religious practices that is a part of the religion that they were biologically born into. So the council like
Mhm.
to re-emphasize that the fact that the ceremony was practiced rightly and willfully with the interest of the person converting in
Got it.
itself.
I got your answer. Now,
And
Do you have anything else to say for the issue 2?
yes, Your Lordship,
Okay.
if the council is permitted, the council could
Yes, yes,
continue.
continue with your argument regarding issue 2.
Much obliged, Your Lordship. Uh, as already mentioned, the belief of a person is being put to test, which is fundamentally violating their self-determination as such, as observed in the nine-judge bench decision. Moreover, the procedure also vests upon a lot of restrictions upon the right to marry of every individual. For instance, to emphasize upon this, I have decisions that the Honorable High Court has also put out before I deal with the right to marry. Your Lordship, the council seeks extra time, if permitted, of 3 minutes.
Okay.
Much obliged, Your Lordship. The court has time and again observed that the right to privacy is also need to be protected of persons converting, and the Himachal Pradesh High Court in Evangelical Fellowship of India was the state of Himachal Pradesh observed that section 4 was considered to be ultra vires because it was penalizing on laws on conversion, and the Suresh Carlton case, another high court decision where it observed that the any declaration sought for conversion is outrightly ex facie unconstitutional, and a declaration regarding being provided the same to the magistrate. This is the section 10 of another state legislation, which was held unconstitutional by a high court, Your Lordship. Moving forward to right to marry, the right to marry is a right that is vested through the personal laws that have been brought out, and time and again the Supreme Court, the apex court in itself, has established that the right to marry, right to choose a partner of one's choice, is a fundamental right. And moreover, a right to form a union has also been observed to be a fundamental right under Article 19, Clause 1, subclause C. And the consent of the family, community, clan is not required for two adults to agree or enter into a wedlock, is what was observed by the Honorable Apex Court in Lakshmibai versus State of Karnataka. If the Lordship shall permit, Council would like to advance arguments for the third issue.
Yes, yes.
Much obliged, Your Lordship. The Council shall answer this in a threefold manner. Firstly, upon the shifting of burden of proof, which is imposing a presumption of guilt. Secondly, the inquiry process, which is unjust in nature. And thirdly, the law which is being discriminative against vulnerable groups. The shifting of burden of proof as such, the whole reversal of burden of proof is operating in a manner that there is a presumption of guilt being levied upon the person alleged to have committed of an offense. I would like the Lordship to note that they are still yet only alleged to have committed of the offense. In Babu versus State of Kerala, it was observed that Supreme Court that the statutory provisions on presumption of guilt must be met with the test of reasonableness the rights under Article 14 and 21. Moving forward, there's a Bombay High Court judgment, case named Sheikh Zahid Mukhtar was the state of Maharashtra, which brought out fold principle on how to prove the reversal of burden of proof. But the basic and the fundamental principle in itself is not satisfied in the instant case, Your Lordship, which requires that the foundational facts on involuntary conversion are to be proved. The foundational facts on how and why the conversion is considered to be involuntary in itself has not been proved by the state, Your Lordship. Moving forward, every person is also provided with the opportunity of being heard under the principle of audi alteram partem, and this right also is outrightly violated for all persons, and the act is unjust under section 9 because the term allurement has not been rightly defined. It is very vaguely brought out, and any penal statute having subjective and vague terminologies will furthermore violate the interests of persons, and the court in Shreya Singhal versus Union of India observed that a penal law which is vague should be
Your
considered as
time is
void.
already up.
30 seconds, Your Lordship.
So you may
Apologies,
sum
Your
it up
Lordship.
and make your prayer.
Much obliged, Your Lordship. Moving forward, the principle of audio alteram partem provided in DK Yadav versus JMA Industries is also violated, and the law discriminating against vulnerable groups is also violated, as observed by this the Honorable Court of India in Najgar versus Hotel Associations. In light of the facts presented issues cited and arguments advanced, this honorable court may be pleased to declare that the Prohibition of Unlawful Conversion of Religion Act is unconstitutional and ultra vires, violating Article 14, 19, 25, and 21. Declare sections 8 and 9 to be violative of right to privacy and personal liberty under Article 21. Declare the provisions of statute pertaining to burden of proof and the inquiry process, mandatory inquiry process, are unfairly violating the principles of natural justice and are unjust, and declare that the act in itself is unconstitutional, upholding the fundamental rights of persons enshrined through the Constitution. Grant any other order that this court may deem fit in the best interests of justice, equity, and good conscience. Much obliged, Your Lordship. It was indeed a great opportunity to have had the opportunity to present arguments in front of Your Lordship.
Thank you.
Indian Council seeks permission to address the court.
Yes, you have the permission.
Much obliged. The Council seeks permission to refer the bench collectively as Your Lordship.
Yes, you have the permission.
Much obliged. Lordship, the respondents has approached the Honorable Supreme Court of Bharat under Article 132 of the Constitution of Bharat 1950, following their prior recourse to the High Court of Bhanu Pradesh under Article 226 of the Constitution of Bharat 1950. Your Lordship, the Council 1 will be dealing with the first two issues, and the rest two issues will be dealt by the Council 2. Your Lordship, as I believe that you are well versed with the fact, Council seeks permission to proceed directly with the argument.
Yes, you have the permission to start
Your Lordship.
directly with the
Your Lordship, I'll be dealing with issue 1 and issue 2. I'll be dealing with issue 1 and issue 2 consecutively, and I'll be initiating with issue 1.
Okay.
Council seeks permission to initiate with issue 1.
Yes.
Much obliged, Your Lordship. Your Lordship, according to Article 25, freedom of conscience and free profession, practice, and propagation of religion is guaranteed to all, which is subjected to public order, morality, and health, as which shall defined under Article 25, Clause 1 of the Constitution of Bharat. Your Lordship, it is to be understood and even noted that freedom under Article 25 is barred by disturbance of the public order. As defined in the case of Ramesh Thapar versus State of Bihar, disturbance in the public order is defined as the act which affects the community at large or affects the life of the particular community. Claiming that conversion of Alex is against the motives of this act seems accurate, since the proposition mentions protest, which is affecting the public order by cultural heritage group against interfaith marriage, which clearly displays the initiation of one of the many communal tensions among one category of the people, hence affecting the life of the people of that particular community. Because of this disturbance in the public order, state under Article 25 Clause 2, it is to be noted, Your Lordship, state under Article 25 Clause 2, that is, nothing in this article shall affect the operation of any existing law. We can take the example of our law, or prevent the state from making any new law regulating sexual activity subjecting to disturbance of the public order. Hence, the Act stands accurate on charges of individuals under Section 3 and 10 of the respective Act are dealing with the situation of disturbance in the public order. Your Lordship, it is further to be understood that there is a difference between right to propagate religion and right to religion under Article 25. We can take the example of case Rain Stanislaus of the state of Madhya Pradesh, where the case disbanded the notion that right to propagate religion meant right to convert one person from one religion to another. It was held that right to propagate religion under Article 25 does not include right to convert another person to one's own religion. The court holds the term propagate only meant the right to spread or disseminate one's religion beliefs, but not to convert others. Here in our case, Section 3 of the respective Act is clearly not violative of Article 25, as during the mandatory inquiry conducted by the district magistrate and even found credible by the district magistrate under Section 9 of the respective Act, it was alleged that the conversion of Alex was not of Alex's own volition, but was influenced by Taylor and her family. As it was concluded by the magistrate that Taylor family promised Alex a job in their business, a luxurious lifestyle, expensive gifts, and incentives of converting. It can be concluded from Rain Stanislaus itself, the Supreme Court reviewed the definition of endowment. Endowment is defined as offering some form of material or financial benefit to persuade a person to convert from one religion to another. These benefits may include visa, money, gifts, employments, promises of better living conditions, or any other form of tangible inducements. The conversion of Alex is direct result of this endowment as defined under Section 3 of
Counsel,
this Act.
tell me what is the criteria for deciding that a conversion is genuine or not under the Act?
The Section 3 defines the criteria of the act if the conversion is genuine or not, where it says that portion, allurement, misrepresentation, if are included in the conversion, that particular conversion cannot satisfy the Article 25 of the Constitution.
So
That
if
is
the
religious.
person who is being converted says that he was not allured, still you are going to charge him under the act?
India, Bharat is a really big and a secular country. We cannot only condemn on a particular person's statement that he was converted or not, because we really don't know if he was particularly coerced or what. Like happened in the case of Shafiya Jahan versus Ashokan KM, where the particular girl was coerced, but still she was forced to say to the authorities that she was never coerced or being allured. But at final, it was authorized. Yes, the girl was coerced, and the religion and the conversion was stated not to be following the principle of Article 25.
But the petitioners have approached this court for validating, getting the marriage validated, getting their conversions validated. So, under the circumstances, don't you think that state is being too much harsh on them and imposing unreasonable restrictions?
Your Lordship, I respectively commits that, but it has also to be understood that allurement, coercement, and misrepresentation are the parts that also have to be highlighted. We know that we are always guaranteed with fundamental rights, but these fundamental rights come with certain reasonable restrictions. And if the fathers of the Constitution has put these reasonable restrictions, we even have to highlight them and look each and every aspect of particular thing. Here in our case, conversion is totally valid, but if it is done by allurement, misrepresentation, coercement, validated by the authorities, should not be allowed to do.
You will continue further with your argument.
If your Lordship is satisfied, Council seeks permission to further arguments.
Mhm.
Are you obliged? Your Lordship, it is to be understood that Act are raised with the principle of Article 25, Clause 2. As even above mentioned, there can be any existing law or a newly made law by the state to regulate or restrict sexual activities under Article 25, Clause 1. Also, the same can be highlighted to the case of Dargah Committee Ajmer versus Sayyid Hussain Ali, where it was said that it is under the domain of the state to regulate secular aspects of religious practice and not just intricate values enshrined under Article 25 and 26 of the Constitution, such as administration to prevent maladministration, which means that the state has the power to regulate affairs under Article 25 subject to administration. In our case also, the Act represents a legislation by state to interfere only with the matters which relate to the coerced, misrepresented, or allured conversions under the shed of Article 25, according to Section 3 of the respective Act. Declaration under Section 8 and inquiry by the district magistrate under Section 9 of the Act is the part of the administration by the state to prevent further maladministration, which does not interfere with any intrinsic religious matters under Article 25 of the Constitution, but with secular matters. Hence, is clearly not violative of Article 25 of the Constitution of Bharat. Hence, it is humbly submitted before this Honorable Supreme Court of Bharat that Act Prohibition of Unlawful Conversion of Religion Act 2023 should not stand in violation of Article 25 of the Constitution of Bharat. Council seeks permission to initiate with issue 2.
Yes, you have the permission.
Much obliged, Your Lordship. Article 21 of the Constitution states that no person will be deprived of his life or personal liberty except according to the procedure established by law. Your Lordship, it is to be understood that the Act adheres with the principle of procedure established by law. As procedure established by law follows two principles. These are the procedure should be just, fair, and reasonable, and the procedure should follow the principle of justice and human dignity. We should understand that the Act follows the principle of justice and human dignity. In the case of D.K. Basu versus State of West Bengal, it was held that exception to Article 21, which is procedure established by law, must adhere to the principles of justice and human dignity. That is, law must be just and following the principle of human dignity. In the respective case, the Section 8 and 9 of the Act are clearly just and follows the principle of human dignity. The declaration of 60 days under Section 8 of the Act prior to the conversion ceremony showcases the justness of the Act, which is necessary to eliminate issues such as coercion, allurement, misrepresentation, generally happens during
But
various
counsel,
cases of convergence.
there is one question in the mind of the bench that whether it is justified to impose penalty. Can you not simply remove the conversion part? Can you not just simply say that conversion is invalid? Why the penalty part? How do you justify the taking away of personal liberty for a wrongful conversion?
Yes, Lordship. Going with the first part of the question, the penalties are imposed in the country like Bharat to restrict further happening of this particular act. It is not necessary that we are only talking about the conversion in our case. It can even be another act. For example, there the penalties are only obliged so that the person in the future adhering to the penalties or adhering with the punishment of the penalties do not do the same thing in the same future. That's why penalties are necessary, and the penalty that is being possessed here is not a very big amount compared to the conversion and the number of the things that are happening there. And going with the issue two,
Mhm.
Lordship,
Yes, yes,
can
continue.
you please? Uh, Lordship, the issue two can be further explained to this point that the inquiry by the district magistrate under Section 9 truly follows the principle of human dignity as stated by the bench, where surveillance conducted by the district magistrate within the period of 21 days is necessary to investigate the intention and purpose of the following conversion, which is to only maintain the dignity of the person getting converted and also the person following the conversion. Your Lordship, it is further to be understood that inquiry under Section 9 is reasonable. In the case of Govind versus State of Madhya Pradesh, the Supreme Court held that the regulations which are force of law are valid. Right to privacy can be characterized as a fundamental right, and also that right is not absolute. So, Lordship, depending upon the character and antecedents of the person subject to surveillance and the object and limitation under which surveillance is made, it cannot be said that surveillance by domiciliary visit would always be unreasonable restriction upon the right to privacy. In the present case also, Section 9 of the Act, which talks about the surveillance conducted by the district magistrate within the period of 21 days, which is necessary to investigate the intention and purpose of the following conversion and to stop the forced or allured conversion. It cannot be said that surveillance put unreasonable restriction upon the right to privacy and violates person's right to personal liberty. Your Lordship, it is to be submitted before the Honorable Supreme Court that Act guarantees freedom of expression to an individual. In the case of Maneka Gandhi versus Union of India, it was held that the Supreme Court that a law depriving a person of right to privacy and personal liberty has not only to stand the test of Article 21, but it also must stand the test of Article 19 of the Constitution. That is, individual must have the fundamental freedoms to express his or her opinion, as even contended by the petitioners. In the present case, the Act clearly gives the opportunity to individual to express his or her opinion by the means of Section 8, where the person intending to convert has the freedom to freely express himself to a declaration where he declares his expression of conversion. Also, during the systematic inquiry conducted by the district magistrate under Section 9 of the respective Act, an individual converting has an appropriate opportunity to express his intention of conversion and satisfy the executive authority through his cause of conversion, that is, following the principle of justness and reasonableness. Hence, Section 8 and 9 of the Act clearly follows the fundamental freedom guaranteed under Article 19 of the Constitution, making itself in line with right to privacy and personal liberty as guaranteed under Article 21.
Okay.
If your Lordship is satisfied, I may begin with, if your Lordship is satisfied, hence it is humbly submitted before this Honorable Supreme Court that Section 8 and 9 of the Act Prohibition of Unlawful Conversion Act Religion 2023 does not stand in violation of Article 81, that is right to privacy and personal liberty enshrined in the Constitution of Bharat. If your Lordship is satisfied and have other further queries, counsel seeks permission for the answer.
No, you can further your speaker too.
Am I clearly audible and visible to the honorable bench?
Yes, yes.
Much obliged, your lordships. Your lordships, I'll be speaker 2 dealing with issues 3 and 4. And with your lordship's prior permission, the council seeks permission.
You have the permission. You
their
can start
arguments.
with the issues directly.
Much obliged, your lordships. Your lordships, it is humbly submitted before the honorable court that the provisions under the Prohibition of Unlawful Conversion and Religion Act, especially regarding the burden of proof and inquiry process, are reasonable, just, and in consonance with principles of natural justice. Your lordships, the argument is further divided into 2 sub-issues. I'll be specifically dealing with burden of proof and then the inquiry process. Your lordships, it is humbly submitted before the honorable court. Yes, indeed, your lordships. Your lordships, under sub-issue 1, it is humbly submitted before the honorable court that the provisions regarding the burden of proof under the Prohibition of Unlawful Conversion Act do not violate principles of natural justice, but are instead a necessary safeguard to prevent unlawful conversions. The act is not designed to target any specific religion or religious community, but seeks to ensure that religious conversions are carried out in a free, fair, and voluntarily manner, particularly given the vulnerability of certain sections of the society, your lordships. Your lordships, it is further submitted that it is well established under specific circumstances that the burden of proof may be shifted to a party where the facts of the particular case warrant such shift. This is not an unusual and unconstitutional mechanism, and it finds precedence in various statutes and judgments of this honorable court. Your lordships, regarding this burden of proof, I'd like to give an example. Your Lordships, what happens in cases of dowry deaths? Your Lordships, there is this reversal of burden of proof. Your Lordships, why does it exist? Because it is not possible for prosecution to pick out evidence. As such, crimes often occur in private space, making it difficult for the prosecution to prove intent, Your Lordships, on the part of accused. Given the vulnerable positions of the victim, the law aims to ensure justice by requiring the accused to prove their innocence once certain foundational facts are met, Your Lordships. In the instant case, Your Lordships, that is the inquiry process that is envisioned in the Act, Your Lordships.
But don't you think that state is becoming too harsh by presuming guilt in such cases?
Your Lordships, only if there is some forced conversion that is taking place, then the state is intervening, Your Lordships.
No, but all the conversions are considered and presumed to be forced. The person converting has to prove that the conversion was genuine and out of his own volition.
Your Lordships, because such conversions takes place in private, Your Lordships. And Your Lordships, some complaints are not made due to pressure from be it families or be it people that
why
are
don't
converted.
why don't you make a law to regulate the conversions rather to penalize them?
Indeed, Your Lordships, this is not a penalizing statute, Your Lordships. It will only be
Is
identified.
it not providing punishment?
Sorry, Your Lordships.
Is it not, the law is not providing punishment?
Your Lordships, punishments are only for people that are found to have been coercing someone.
That is exactly my question
Yes,
to the respondent side. That the state can very well make a law, but they chose to make a law which is penalizing in nature, which is putting a person behind bars only for conversion. In the alternate, what the state could have done, they could have established a proper procedure for conversion.
Indeed, Your Lordships are wise in stating that. Your Lordships, however, given the candlestick and often the nature of coercion or undue influence, it is reasonable for the legislature to mandate that the person who has undergone conversion and the person that has made such conversion happen to demonstrate that such conversion was not a result of fraudulent inducement, coercion, or allurement. Your Lordships, coming to the part of definitions, as the side petitioners had contended that correct definitions had not been provided. Your Lordships, I'd like to reiterate the position of the side respondents that this is not the entire act. Your Lordships, section 2 generally constitutes of definitions, be it voluntarily, non-voluntarily conversions, allurement, coercion, and such definitions are clearly put out, Your Lordships, in acts, Your Lordships, and therefore clear definitions have been provided. Coming to my next submission, Your Lordships, it is further submitted that the prohibition of unlawful conversion of Religion Act 2023 is in consonance with the reasonable restrictions permitted under Article 25, Clause 2 of the Constitution. The Act does not impede an individual's right to profess or propagate their religion, but it restricts unlawful means of conversion, such as those achieved through force, fraud, or allurement. Your Lordships, Speaker 1 also iterated the case of Rev. Stanislaus versus State of Madhya Pradesh, which univocally held that while the right to propagate one's religion is a fundamental right, it does not include the right to convert another person against their will, as such acts can have deterrent effects on public order. Your Lordships, the Act's provisions are designed to ensure that conversions, particularly those involving vulnerable groups such as women, children, SC, STs, are carried out voluntarily and without any undue influence. In this aspect, the Act mirrors legislative safeguards in other countries that have enacted similar anti-conversion laws to protect public order and individual autonomy. Your Lordships, such countries are such as country of India, Your Lordships, wherein different states have enacted such laws to regulate these unlawful religious conversions, Your Lordships. If Your Lordships are satisfied with my submissions.
Yes.
Much obliged, Your Lordships. Your Lordships, under submission 2 it is humbly submitted before the Honorable Court that Your Lordships, that the state is fulfilling its constitutional obligations. And Your Lordships, the notice period under Special Marriage Act has also been upheld by this Honorable Court in Seema versus Ashwini Kumar, where the court recognized the need for such procedural safeguards to protect individual autonomy and prevent exploitation. Similarly, the inquiry process under the Prohibition of Unlawful Conversion Religion Act 2023 ensures that no individual is exploited through religious conversions and that the conversion is based on free and informed
Counsel,
consent.
I have one question, that how the section 8 of the act is applicable to the present case.
Just a moment of indulgence, Your Lordships.
Section 10, sorry.
Section 10, indeed,
Yes.
Your Lordships. Your Lordships, in the limited knowledge of counsel to Section 10 would not apply in the current case, Your Lordships. Since
Why?
Your Lordships, the exact caste or tribe of the person have not been given, and it is to be understood that the person that is marrying is a major, Your Lordship.
Okay. So then the petitioner's case would have strength.
Your Lordships are wise in stating that, but Your Lordships, it is pertinent to note that the petitioners did not argue issue 4, Your Lordships, and did not make submissions in regard to issue 4.
That is separate issue. I'm just putting you a query.
Your Lordships are wise in stating that, but if Your Lordships may let me finish my issue 4, and if that would sufficiently answer Your Lordship's question, that would be very nice. Much obliged, Your Lordships. Your Lordships, it is humbly submitted before the Honorable Court under issue 4 that the state-imposed restrictions on religious conversions are to prevent forced conversions, and the state's interest in protecting the individuals justify the restrictions imposed by the Act on the right to convert and right to marry. Your Lordships, again, this issue is twofold. Your Lordships, under first sub-issue, it is humbly submitted before the Honorable Court that the state has legitimate interest in preventing these coerced conversions. It is humbly submitted that the state's interest in regulating religious conversions is reinforced by the need to protect vulnerable sections of the society, Your Lordships. That is Section 10 that Your Lordship just talked about. The Act specifically seeks to shield children, women, and members of scheduled caste and scheduled tribes from being exploited under the guise of religious conversion, Your Lordships. Your Lordships, this Honorable Court, in the case of Srimati Sarla Mughal versus Union of India, acknowledged the state's role in protecting women and other vulnerable groups from being manipulated through fraudulent conversions, particularly in the context of marriage. In the light of these particular duties, the Act ensures that no one is coerced into conversion, a safeguard that is necessary in a pluralistic society such as Bharat, where religious diversity must be preserved without any particular group being unduly influenced or coerced, Your Lordships. Your Lordships, my speaker one also reiterated the case of West Amulus versus State of Madhya Pradesh, wherein the Honorable Supreme Court upheld anti-conversion laws, holding that the right to propagate religion under Article 25 does not include the right to convert someone, Your Lordships. Your Lordships, coming to my sub-issue 2, Your Lordships, that the Act is reasonable and a proportional regulation, Your Lordships. Your Lordships, it is humbly submitted before the Honorable Court that the individuals who convert from one religion to another under coercion from those who do so voluntarily is based on intelligible differentia and proper definitions as to what would constitute a voluntarily conversion or involuntary conversion or non-voluntary conversion is defined under Section 2 of the said Act, Your Lordships. The Act aims to protect the autonomy and freedom of individuals in religious matters without infringing on their right to freely choose their religion, Your Lordships. Your Lordships, it is further submitted that the religious conversions may be viewed as an expression of one's beliefs. The restriction imposed by the Act are designed to ensure that such expressions are free from fraud and coercion, Your Lordships. Your Lordships, it is further submitted that the religious conversions, especially in the context of interfaith marriages, fall under entry 5 of the concurrent list and entry 97 of the center list, Your Lordships. Your Lordships, this Special Marriages Act, which governs interfaith marriages and mandates procedural safeguards, is a central legislation enacted under the same entity. The present Act mirrors such provisions, attempting to only regulate conversions through notice and inquiry processes in the context of interfaith marriages particularly, which clearly falls under the concurrent list and which requires the state and center coordination, Your Lordships. Your Lordships, it is therefore submitted that the restrictions imposed by the Prohibition of Unlawful Conversion Religion Act 2023 are constitutionally valid. The Act is reasonable and proportionate measure. aimed at preventing fraudulent and coercive conversions while safeguarding the right to religious freedom and the right to marry. The state's interest in protecting vulnerable individuals justifies these restrictions, Your Lordship, which are consistent with the principles that are enshrined in the Constitution as well as upheld by this Honorable Court, Your Lordships. If Your Lordships are satisfied with my submissions.
Yes, yes.
Much obliged, Your Lordships. The Council seeks permission to proceed with the statement of prayer.
Yes. You may
Much obliged, Your Lordships.
start with the prayer.
Therefore, it is prayed, in the light of issues raised, arguments advanced, and authorities cited, that the Honorable Supreme Court may be pleased to adjudge and declare that 1. The Prohibition of Unlawful Conversion of Religion Act 2023 aligns with the fundamental right to freedom of religion guaranteed under Article 25 of the Constitution of Bharat. Number 2. Section 8 and Section 9 of the Prohibition of Unlawful Conversion of Religion Act 2023 adheres with the Article 21 of the Constitution of Bharat and is a procedure established by law. Number 3. The Prohibition of Unlawful Conversion of Religion Act is constitutional as it aligns with the Article 14 of the Constitution of Bharat, hence must be maintained as constitutional, and or pass any other order, direction, or relief that it may deem fit in the best interest of justice, fairness, equity, and good conscience. For this act of kindness, the respondent shall duty bound forever pray. It was an honor arguing before the honorable bench. With that, the respondents would like to rest their case.
Thank you.
Much obliged, Your Lordships.
The petitioner seek permission for rebuttals.
Okay, you have the permission to rebut.
Much obliged, Your Honor. The learned counsels, opponent counsel had stated that act affects public order and communal harmony. How does a private individual's religious conversion disturb public order as prescribed by the state? That is the first question that the council would like to raise. Secondly, Alex
Counsel, you need to answer these questions as well. You don't raise questions. You need to answer these questions.
Yes. Pardon, sir. Could you please repeat? I beg your pardon.
If you think there is some question which is arising out after hearing the respondent side,
yes,
then you will clarify to the court that
okay,
this is the question which has come out, and I will answer it in my favor.
Yes, definitely. Sorry, sir. Thank you for the clarification. So, so basically, my respected counsel had stated that act affects public order and affects communal harmony. The learned counsel is of the opinion that that is not how it happens. How does a private individual's private matter, that is their personal liberty, that is as enshrined in Article 21, is being exercised there while they're converting to another religion? While you're going against personal liberty, Article 21 is infringed. By that principle, Article 14 and 19 is also infringed. So in that essence, a private individual's function, how can it possibly infringe upon all of these aspects? That is the first rebuttal that the petitioner side have. Secondly, Alex had voluntarily submitted for the conversion. There was no the fact that only the gifts were given when he was not having any job you can't clearly say that is allurement, undue influence, or anything of that sort. So how can the learned counsel state that there was undue influence or allurement when Alex had voluntarily submitted the declaration on conversion and stated it was a personal decision? When the couples were questioned, adult 18 plus adults were questioned on this, how can you necessarily say that there was coercion or undue influence? This is the exact same circumstance which happened in Shafin Jahan versus K.M. Ashokan. Thirdly, the petitioners would like to bring about the fact that an individual's right to choose and decide is subjected to the scrutiny of district magistrate. They are full-grown adults. 18 plus adult. So the Apex court had also observed in Puttasamy that the person's mental integrity and privacy sanctions the person with freedom to believe in what is right to think and the freedom to self-determination. So don't the learned opponent counsel feel that while such a scrutiny is established, the right to self-determination of an adult in the country of Bharat is being grossly violated with. With that, the petitioners would like to end the rebuttals. Much obliged, Your Honor.
The Council for Respondents would like to answer some questions that are presented by the petitioners and reiterate
Yes,
their
you may.
much obliged, Your Lordships. Your Lordships, it is pertinent to note that under Article 25, there are certain restrictions that are based on public order. Your Lordships, now they have asked a question that how this particular religious marriage would affect public order and communal harmony. Your Lordships, it is pertinent to note that conversions by misrepresentation, force or undue influence, coercion, or allurement, your lordships, are a violation of public order and not in consonance with communal harmony at all. Your lordships, and as my speaker one has also iterated, the case of the Shafin Jahan case, your lordships, wherein a major took a decision and stated before the honorable court that that such conversion was not forceful. However, it was found out that the conversion was forceful indeed. Your lordships, the council contradicted themselves, your lordships. Your lordships, petitioners escaped your lordships questions that the conversion only for marriage is constitutional or not, your lordships. Your lordships, the respondent would like to submit that such a marriage is not constitutional, your lordships. Your lordships, there are, in fact, many famous cases such as the Bollywood case of Dharmendra, a Bollywood star who converted just to marry your lordships, and further it was held by the Supreme Court that such conversions are not valid, your lordships. Your lordships, coming to the point of audi alteram partem, your lordships, which the side petitioners presented. Your lordships, there is an inquiry process that is conducted where both the parties are heard. Your lordships, officials such as district magistrate, your lordships, are accountable to higher judicial bodies. The DM has quasi-judicial powers. Your lordships, DM holds extensive administrative expressions, handling law and order, and has the requisite knowledge to oversee such process objectively and without any biasness, your lordships. If your lordships are satisfied with our submissions and if I have sufficiently
But these matters are more suitable to be decided by the judicial courts, don't you think?
indeed, your lordships are wise enough to state that. However, your lordships, burdening the judiciary with such cases when they can easily be resolved at a lower level, your lordships, is what the government aim to do, your lordships. Much obliged, your lordships. With that, the respondents would like to raise their case.
Your Lordship, if your Lordship shall permit, counsel for petitioners seeks an opportunity to do a surrebuttal if permitted, your Lordship.
You want to rebut it again?
If the rules of the competition outlaid on rebuttals and surrebuttals to be included,
Okay.
so we just wanted to know if the petitioner counsel for
Okay,
petitioners
you
have
have your 2 minutes.
Much obliged, your Lordship. Firstly, to begin with, your Lordship, my learned counsel from the opponents, my learned counsel for the respondent had, during the course of their presentation of arguments, mentioned that marriage was not marriage was done for purpose of marriage was not done for conversion. We need to emphasize on this because it was emphasized that marriage herein was primarily done for conversion. That would amount to a presumption of fact from the end of the learned counsel for the respondents, your lordship. Additionally, it was emphasized that the right to convert per se. Am
But
I
it has been
audible, your
clearly
lordship?
stated in the facts. It has been clearly stated in the facts that Alex converted on the asking of
Your lordship, if I could
yes,
substantiate herein, much obliged, your lordship. The facts in para 2, line 1, clearly expresses that it was his personal choice. And apart from it being a personal choice, I'm assuming your lordship is emphasizing on the gesture of unity being emphasized upon. But presumption that it is just the gesture of unity that led Alex or the petitioner or any other person like that of petitioner to convert would literally be a presumption which is being imposed upon all persons who are even willingly choosing to convert, merely because they're not being in a position to express or substantiate or prove the belief that they have. They're not able to believe the thought that flows in their mind. then that would amount to outrightly violating of the fundamental right. How does a private, if the council can continue on
Yes, yes,
rebutting?
yes. Agree.
With regard to the first question on how does a private individual's religious conversion disturb public order, for which my learned co-counsel with respondents had emphasized how the argument was in itself defeated, which is where I would want to clarify herein. Basically, that the private individual's religious conversion, how will it amount if the counsel is provided with 2 minutes? I don't, Your Lordship.
Go on, go on.
Yeah, so if a person is if a person's a procedure being imposed on both voluntary and involuntary conventions is one and same, and there's also a presumption that there is a possibility of involuntary conventions, but both persons are being imposed upon with a inquiry process and a declaration. The problem with the inquiry process is that it is also forcing persons to provide data, which is all, like the right of self-incrimination is also a right which is vested with persons, and that right is also being violated as they are being forced to subject themselves to inquiry process, and they're not being adequately heard. As from the facts, the outlay of facts that we may see, it is observed that there have been allegations from the end of parents in regard to the matter, but there are no facts to substantiate on the position advanced by the petitioners in the instant matter. The principle of audi altrum partem is indeed outrightly violated, Your Lordship, and Alex voluntarily submitted a declaration on conversion, and it was his personal decision. And spatial privacy, information privacy, and sensitive personal data, which includes the right of, which includes identity as such, is primarily being violated here in Your Lordship, because case Puttaswamy, a landmark decision which brought out 9 types of privacy, one amongst which is spatial privacy, a a decision that is very much integral to what a person's identity is. Religion, gender are all matters representing an identity of an individual, and such a decision, a person being led by the state to take such a decision, is outrightly violative. A, B, there is also circumstances where it has been observed that it is possible that the state having state could also the influence that the state has should also not amount to any sort of a judicial overreach, Your Lordship. As much as earlier Your Lordship had observed that such decisions should also be brought to judicial scrutiny, but primarily a person's individual decisions. The conversation that we are having herein, every thought being subjected to judicial scrutiny could amount to judicial scrutiny, is what I would humbly like to submit to this bench, Your Lordship. And thirdly, with regard to the individual's right to choose and it being subject to scrutiny is also something I've answered already, Your Lordship. So if Your Lordship shall permit, I shall rest my argument here.
Thank you.
Much obliged, Your Lordship.
Your Lordships, with your Lordship's prior permission, I'd like to answer in just 30 seconds, Your Lordships, the queries that were raised by the side petitioners, Your Lordships.
This is not going to end like this.
Your Lordships, just 30 seconds. I'd finish it in 2 sentences, Your Lordships.
Okay, okay.
Your Lordships, in the Moot proposition, the final paragraph, Your Lordships, it is answered by jurisdiction, which the side petitioners have contended it is Article 32, but it is 132. Your Lordships, the matter was previously before a lower court, that is the High Court. Your Lordships, I'd like to state this paragraph. Alex and Taylor filed a writ petition in the High Court of Bhanu Pradesh challenging the constitutionality of the Prohibition of Unlawful Conversion of Religion Act 2023 and seeking quashing of charges against them. Your Lordships, it is a point to be noted that before the Honorable High Court, they have already submitted their facts, seeking quashing of the charges against them. The High Court dismissed their petition, upholding the validity of the Act. And now Alex and Taylor are before the Supreme Court. Your Lordships, under Article 132, clubbed with Petition 32 because it is a constitutional challenge. Your Lordships, it is to be noted that High Court has already looked into the facts that were alleged in the Moot proposition. The High Court has substantiated those particular facts. And Your Lordships, the Honorable Supreme Court that we are arguing right now in is the court of law, Your Lordships. We'll be discussing questions of law, Your Lordships. The facts are established and they favor the respondents, Your Lordships. If Your Lordships are satisfied with the submissions,
actually, you're wrong on this. The Supreme Court will have the power to listen to it still.
Indeed, Your Lordships. That is, Your Lordships are wise in stating that. And if I may be bold enough to state that Honorable High Court had looked into the facts, Your Lordships.
Honorable High Court has already looked into, but it will not debar the Supreme Court to look into the matter again.
Indeed, Your Lordships. Indeed.
For the constitutional validity, at least.
Indeed, Your Lordships.
Thank you. Thank you for your arguments.
Much obliged.
Thank you so much, participants. As for the results, I request Sir to kindly wait as our Moot Court committee will get in touch with you soon for results. Thank you so much, everyone.
Thank you.